456 hereby ceases to investigate the complaint any further as the invocation of the Article 146 proceedings have effectively taken the matter out of the forum of the commission, and is signed by Joseph Whittal, the commissioner.
So that is Shraj's decision on this, saying that the matter in which you want us to look into is currently before an appropriate forum. But ASERPA disagrees with that position. And at a news conference today, the executive director, Mensah Thompson, said that Shraj simply engaged in speculation.
Since Shraj claims that it was conducting preliminary investigations when it was brought to its attention that another process has been commenced by the petitioners, who brought this second case to their attention? Does the person or institution has a name? Because this was an investigation, it was we, the petitioners, drawing our attention to the double action and put us to our election to stay one of the actions, as quoted in their own report in the case of Paramount Stool of Biamanko, Ifia, and another versus Nana Taiba and others. 3. Where in the Shraj Act does it say that an action commenced in the same matter in another forum automatically truncates an ongoing investigations by Shraj?
So that is Mensah Thompson, the executive director of ASERPA. But in a related matter, this time on their petition to President Akufo-Addo demanding the removal of the CJ, you recall that on Friday, the Council of State presented the outcome of its deliberation on a petition to the president. The president, in receiving the petition, said this.
I understand that the process of the impeachment of the Chief Justice, indeed, of Justices of the Supreme Court, are meant to be in-camera proceedings, so that the contents of the consultation between the two of us, your side is in the letter and my own is also there, will for the time being remain confidential until we're in a position to announce the result of it to the world. But I have first to thank you very much for the assiduous and punctual manner in which you continue to carry out your functions as the Council of State.
And so that is President Akufo-Addo saying that the matters must be held in confidence. But we are learning that the presidency has actually written to the petitioner in this case. We'll bring you details of that response from the presidency. But Mensah Thompson at the news conference today responded to President Akufo-Addo's view of the process. He was demanding that the process be made more transparent. Listen to Mensah Thompson speak today at the news conference.
First of all, the president must not confuse the term in camera with secrecy. The fact that the law says the processes must be held in camera does not mean the process should be a secret mission. Transparency is the name of the game. The public, the petitioners, must all be properly informed every step of the way, because no government business is conducted in secrecy. Secondly, what sort of interference is this, Mr. President? Under the law, the president is only a conveyor belt and not an investigator. Even though we have argued that the non-existence of a prima facie determination in this matter, the Supreme Court ruling plays the inherent role with the Council of State and not the president. The Council of State has completed their work. Now the president is saying he is also going to appraise the Council of State with his own findings to ensure they are on the same page. What is this? Who asked the president for his opinion in this matter? We contend that the president should not interfere with this constitutional process and must stick to his functions as spelled out under Article 146 of the 1992 Constitution. Ladies and gentlemen, a prima facie determination is not a full-scale investigation. It is just a determination to see whether there is something to look into in the first place. And if you ask me, if a member of the bar makes a categorical allegation of bribery and extortion against a sitting Chief Justice, shouldn't we at least want to get to the bottom of this matter?
Now, in the last few minutes, we have received a copy of that response from President Akufo-Addo to the petitioner, Mensa Thompson, in this case, demanding the removal of the Chief Justice. It's an 11-page document, and I'll just read the conclusion of this response. It says that it is obvious that from the above, and the above here referring to a case that is Ejechum versus Attorney General, and this is a judgment delivered by Justice Databa. It says, from the above, the Supreme Court, in interpreting Article 146, had in mind unmeritorious and unwarranted petitions, such as the instant one. The petition is dismissed accordingly, and that is the conclusion of President Akufo-Addo in determining whether or not a prima facie case exists for any further probe against the Chief Justice. Mensa Thompson is the Executive Director of ASERPA and joins us on the line. Let me start with the latest development, Mr. Mensa. Your petition to the President has been dismissed. Your reaction?
Yes, thank you very much. First of all, today is a very sad day for the history of the judiciary and also for the history of our democracy. And once again, President Akufo-Addo has shown that he has absolutely no respect for the laws of the country. And again, considering what has been done and the effect of such backlash, the Council of State submitted the petition to the President on Friday. The President writes this ridiculous report and then just off outside the country to avoid a public backlash. This is very shameful.
When you say the president doesn't have regard for the law, how do you mean? Because you have a copy of this response, and it gives you a detailed response quoting the law, giving you case laws to back this. And so how do you mean when you say the president has no regard for the law?
Well, under Article 146, the president is only a conveyor belt in this matter. The opinion of the president, it doesn't matter in this matter. The Council of State did their report. We don't know the content of the report of the Council of State. The president said he was going to apprise himself, or he was going to apprise the Council of State with his also findings on an investigation he also went to do to ensure that they are on the same page. So we don't know if this report that they are reading is actually the report of the Council of State or the report of President Akufo-Addo's own investigation. We don't know.
Now, Mr. Thompson, let's move to the other issue, because this is a two-sided issue. You petition the president and then you petition Strach. You're saying that you do not agree with Strach's position. Now, I know that you're not a legal practitioner, but you have been conferring with your lawyers all along. When I spoke to you over the weekend on the news, did your lawyers, what advice or what did they tell you about this legal principle that Strach refers to in their response to you, which essentially says that it is a principle of law that special provisions take precedence over general provisions? Isn't that enough grounds for Strach to proceed to decline your request for a probe? What advice have your lawyers given you on this?
As for Strach's report, the least said about it, the better. And continuously, we are getting worried, increasingly worried about the kind of report Strach is taking out. Look, if you read Strach's own report, the case reference which they cited, the paramount of Biamanko and Ifia versus Nana Taiba and Addis, where they quoted the ruling of CJ, Justice Abbott, that when an action or a plaintiff files or sued the same defendant in two courts, the plaintiff put his own election to pay one of the proceedings. This is what Strach report is saying. So, under the case in reference, if it is presumed that we, the petitioners, filed two actions against the same defendant in different courts. The court should put we the plaintiff of petitioners to election to decide which of the two should continue and which of them should stay. At what point the Shraj write to us for us to elect which of the actions should stay and which of the actions should proceed? So Shraj sat in the comfort of their office and unilaterally decided to violate the right of we the petitioners, deciding which of the two actions should stay and which of them should proceed.
Mr. Mensah, you're saying that after you filed this petition, you never heard from Shraj until
Never.
they released their report or response to you.
Never.
Hold the line
Never.
for me on that. Hold the line for me on that, Mr. Thompson. We're privileged to be joined by former Commissioner of Shraj, Emil Short. Sir, we are grateful for your time here on Top Story. I want to start with the last concern that ASEPA raises about Shraj's position on their request for a probe. He is saying if Shraj indeed is saying that another petition has been filed and that is a more appropriate forum, Shraj should have invited them at least to first of all make a determination as to whether they want to proceed with their process or they would want to go with what Shraj describes as an appropriate forum, the petition filed at the presidency. What is your take on this, sir?
I don't think that position is right. Shraj has discretion to discontinue an investigation which it has started when it comes to its notice that the same petitioner has filed a similar petition to another judicial body. So when you have a petitioner having filed the same petition between two judicial or quasi-judicial bodies, Shraj can refuse to investigate because Shraj has the discretion to discontinue the investigation if under the law there is a remedy which the petitioner can avail himself of. There is also the position that the law frowns on a petitioner filing the same petition to two different judicial or quasi-judicial bodies. It amounts to multiple forum shopping. So I think, but the most important section of which I think Shraj relied on is, I think, Section 13 of the Act, which
Yes.
provides that if in the course of investigation a matter, it comes to the notice of Shraj that a similar petition has been filed with another body, then it has the discretion to discontinue the investigation, and it need not invite the petitioner to exercise an option as to which body it would discontinue the petition with. It is not a matter for the petitioner to decide, but Shraj itself has that discretion under its law. So I think that the position taken by Shraj is the correct one.
We would want to thank you very much for bringing us clarity on this. That is Justice Emil Short, a former commissioner of Shraj himself, speaking to the concerns raised by ASEPA when Shraj decided to turn down their petition to investigate the Chief Justice on an alleged bribery case. We're joined by private legal practitioner Samson Ladi, and Samson has worked extensively on Article 146, which is the impeachment processes there. Samson also dealt with the particular case of Loretta Lamte, which led to her exit from Shraj. Thank you very much, Samson, for Mr. Yenene, for joining us here on Top Story. Let me start with the position again by Shraj. The concerns raised by Mensah Thompson and ASEPA, that Shraj ought to have invited them, to have heard from them, before coming to the conclusion, and that it simply engaged in speculation by not at least even referring to what it claims as the other petition filed at an appropriate forum. Should the report at least should the report have mentioned that it is aware that this was brought to its attention, first of all, and then by whom?
All right. So even before today, I like to make a statement that whilst I take the view, a professional view, that this petition will be the most frivolous and basic, baseless petition to be entertained in the history of this country in seeking to remove a justice of the Supreme Court or of the Superior Court or the CJ for that matter. I have also monitored how the petition has sought and acted completely to suggest that the petitioner is not being advised by a lawyer, but attempting to, suggest an understanding of the process in a manner in which he speaks with a certain conclusive emphasis. That is very disturbing. And in the way he speaks on the issue, he has always been wrong. So I'll proceed to that, but let me let you know this.
Yes.
That I would be shocked if this petition was entertained any further, if it is not thrown into the dustbin for what it is worth. Now, he said, Shraj invited them, heard them first, and put them to their election, whether Shraj will entertain this one or the one that they have sent to the president for the purposes of an Article 146 process ought to go. He says that how could Shraj say that we have heard of another one without stating who, intimated them and the rest of them?
Exactly.
Our law, the Evidence Act, gives judicial authority and those exercising adjudication on matters to do what is known as take judicial notice. That is to say that a matter is so notorious that they cannot blink. They cannot say that they are unaware of it. They don't need to name anybody. The people in charge live in this country, and they are aware that there's a petition before the president. Now, while these petition processes ought to be dealt with in the utmost confidentiality because that is what the law provides, they have been all over the place talking about the fact that they have put a petition there and even suggested that the president was bound to suspend the chief justice. When the law, clearly, you don't need to be a lawyer to have read the law to know that the president is not bound to suspend a chief justice because they put a petition there. Even if it were any other superior court judge or a commissioner of charge or, say, a commission chairperson, or it was a person from a commissioner of NCCE, who are all subject to Article 146 process, the law is so clear. It doesn't say that once you put a petition there, the president is bound to suspend them. And yet they were pushing this and putting it so strongly. So I am afraid, and I'm sorry to say to them, that they need good legal guidance. And in the absence of that, they should stop speaking with emphasis and conclusiveness in the manner they continue to do.
And just before you go, Samson, very briefly, the issue about the president, they requesting the president to make public the decision of the Council of State, is that also founded in law?
When you see the requirement for prima facie to be made, as in a decision to be made to the effect that there is a case for the person who is accused to answer. That's simply what you mean by prima facie. Prima facie means that there is evidence that is sufficient to discharge the burden of proof borne by one party, and that may be sufficient, to actually warrant looking into a data by reasonable inference of the existence of what you claim you are complaining about. That was provided in the law for petitions against all others except the Chief Justice. But in 2005, Brian Akwete took a case to the court because he was seeking to a removal of the Chief Justice. And the Supreme Court took the view that there was an omission by the framers of the Constitution by not providing that when it comes to the Chief Justice, there must be a prima facie to be made.
Okay.
So in all other cases, prima facie will be made by the Chief Justice. But when it involves the Chief Justice, then it has to be the Council of State actually acting together with the President. Now, the framers in the draft for the Constitution itself, they had suggested that job should be given to the Judicial Council or Council of State, as in the lawyers that work for the Council of State.
Yeah.
And they suggested also that the presidency or the Council of State would hire a lawyer who is independent to do that job, because the reason the president is not supposed to be the one to do that job is that we cannot guarantee that you will have a president who is a lawyer. There can be a president who is not a lawyer, and by virtue of not being a lawyer, will not be able to exercise this duty, which is more legal than it's non-legal. So, if the decision is made that a prima facie determination is made, and look, I am telling you that as far as I'm concerned, and having gone through this process before, I will be shocked if a prima facie is made that this case should go forward. It is very frivolous. And I'm stating that with all the emphasis I can master, because it borders on rumor.
Very
you see, for example, when we put the petition, which I did, when we put it before the president, it was forwarded to the Chief Justice. We have submitted evidence, documentary evidence, and then the party who was involved, Loretta Lampe, was asked to bring her response for the Chief Justice to be able to determine whether there was a prima facie case or not. In this case, I don't know if they are going to ask the Chief Justice to also bring his point for them to consider. But it will be so needless because they are peddling rumor, nothing more. And you can't make a prima facie, determination on a rumor.
Very well. Samson, I want to thank you so much for joining us. That's a private legal practitioner, Samson Ladia, joining us with some legal education on this process. So the latest is that the petition by ASEPA for the removal of the Chief Justice has been dismissed by President Akufo-Addo. That's it for Top Story, brought to you by GASEM, the Nation Builder, and Vodafone. Together we can. Newsnight starts now.